Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner with Sumner Immigration Law, and in this video, we're delving into a bit more detail on the J-1 classifications for interns and trainees. The intern classification is designed for foreign nationals who are currently enrolled in a degree or certificate granting institution of higher education, post-secondary educational institution, or a person who has graduated from a post-secondary institution within the past 12 months. When I say within the past 12 months, I mean within the past 12 months as of the date that the J-1 program begins here in the United States. The duration of the intern program under this J-1 classification is up to 12 months. On the other hand, a J-1 trainee is for foreign nationals who have already graduated with the degree or certificate from a post-secondary institution and have at least 1 year of experience in their field or their occupation, or for individuals who have at least 5 years of experience in their particular occupational field. The trainee program is valid for up to 18 months within the J-1 visa program. It's important to note that a foreign national who holds J-1 status as an intern or trainee may be subject to the 2-year home residency requirement under Section 212E of the immigration law. We talked about that in a bit more detail in the previous video that you can reference. In addition, the internship and trainee programs are limited to certain fields. It's not available for every single field that's out there. So that's something that you'll want to explore closely or talk to your immigration attorney about before you commit to fully going down this path. In addition, it's not possible for an employer to simply submit a petition for a J-1 to host a J-1 trainee or intern. In fact, this is not something that is submitted to USCIS. Instead, this program is run by the Department of State. So if an employer plans to hire a lot of J-1s, they can become vetted by the Department of State and other agencies and actually become able to be their own sponsor. If an employer doesn't want to go through that process, let's say they plan to only hire one or maybe a handful of J-1s across a period of time, then they can work with a J-1 sponsor. That is an organization that has already been vetted by the Department of State, and they are authorized to issue what's called the DS 2019, which is the document that the Department of State will ask for when a person goes to apply for the J-1 visa. So in the context of J-1 interns or trainees, the sponsor organization would review the training program or the intern program. They have very specific requirements that they're looking for, and they would approve that before it's submitted to the Department of State, and the J-1 process is completed, wherein the person receives the J-1 visa. The host, on the other hand, refers to the organization, the employer, the institution, whatever it is, who's going to actually host the trainee or the intern. So that person can work with a Department of State vetted sponsor in order to have this person complete the training plan, the intern plan, and actually obtain the J-1 visa. Finally, different sponsors may have different requirements that are not necessarily in the regulations. They have the responsibility to make sure that the host organization can actually provide the training and internship experience for the foreign national. So they may require a minimum number of employees or a minimum number of years in business before they are actually able to work with you. So that's something to keep in mind. It may not be in the regulations, but it may be their own requirements. I hope that you found this information helpful. Our next video will be on the L1 visa classification. Until next time, I'm Emily Sumner.